Hello, welcome to Legal Action. My name is David Siegel. Today we're going to be talking about bankruptcy, specifically Chapter 13 bankruptcy, which is reorganization, with an emphasis on lien stripping, removing that second mortgage that may be unsecured. Joining me again is Jesse Barrientos, my co-host. Jesse, how are you today?
Excellent, Dave. How about yourself?
I'm doing well.
Fantastic.
Chapter 13, Jess.
Chapter 13. I know you mentioned stripping, and so it's very important when people think about stripping, when you're talking about it in the context of a Chapter 13 or Chapter 7, what does it mean? It means just ripping something, a right that somebody may have had.
Right. We're talking about stripping a lien, taking a second mortgage in this instance who has a lien against the real estate and turning that secured mortgage or secured lien into an unsecured lien. So let's say there's an $80,000 second mortgage. If that second mortgage is completely unsecured, meaning the house is worth no more than what the first mortgage is by itself, we can sometimes turn that $80,000 mortgage into an $8,000 unsecured debt and pay it off over the next 3 to 5 years.
So even if the line of equity, so your second mortgage, is secured by the house itself, if the total value is not exceeded, or if the total value is, so basically if you've got a $100,000 home that's worth $200,000 and you have a $200,000 mortgage and you have a $50,000 second mortgage, well, if the home is only worth that much and that's what you owe, so that's what you're saying, then that other one, the $50,000 second mortgage, that can be converted into a...
In a Chapter 13, that second mortgage, if it's completely unsecured, no portion of it can be secured.
What if it's $1? What if it's $290? What if it's $200,000 and that's the value, and you owe
that $1,
$199,000?
That $1 prevents it from being strippable.
The whole thing?
The whole thing.
So basically, then, in that situation, I'd also have to pay back or owe that second mortgage in its entirety.
That's right. But if you're close, like you said, $1, I would just wait right now because the market values are dropping. So if you can wait and time the filing. Now there will be a hearing on valuation if the mortgage company or lien holder disputes it. But in many cases, houses are so far underwater that there's no question that the second is completely unsecured, so it can be stripped and treated as an unsecured creditor, much like a credit card, medical bill.
So as low as 10%?
As low as 10% or less, depending on your case.
Or even less. I thought
less.
You could do only up to 10%, Dave, with unsecured loans.
It could be less than 10%.
How much less, Dave?
Well, it could be 1%. It could be 0%.
Could it be 0?
Technically. It could. But you're going to have a hard time getting your case approved at that rate. You want to be reasonable. You want to pay back at least a portion of your debt over time.
So it could be something.
It could be something. It depends on your income, your expenses, the means test, and of course your total outstanding debt.
Well, let's just digress just for a moment so the folks at home have a good understanding of the difference between a Chapter 7 bankruptcy and a Chapter 13. And I know we've talked about this issue a lot of times before on our show, and it's important, I think, for the people at home to understand.
Have we talked about it?
We've talked about it. It's important for them to understand. We continue to talk about this because this continues to be a source of relief for the people that are out there in these trying economic times. And it's important to get the word out, and it's important that they are informed of what it is. So tell us in the nutshell what the difference is, Dave.
Well, it's a constitutional right to file a bankruptcy and get either a fresh start under Chapter 7, which is a complete elimination of unsecured debt that can be eliminated, or Chapter 13, which is debt reorganization, where you're repaying all or a portion of your debt over the next 3 to 5 years. And it's interesting that Chapter 7 and Chapter 13 both are specific numbers in the game of craps. I don't know if it's a coincidence or not, but they both have something to do with that. I don't know if there's a gambling
Chapter
connection.
7's a winner, right? I'm not sure. What is 13?
13's a winner too on certain
13's a
rolls.
winner.
You bet. But
Okay.
no, in all seriousness, it's for people who are struggling financially, who need to avail themselves of federal law, the constitutional right to file bankruptcy, which goes back all the way to the Bible, which was then adopted by countries and civilizations.
The year of Jubilee, right, Dave?
That's correct.
Where every 50 years, everything is given back to everybody else. So in other words, if I lent property, you get it back.
Yeah.
Everything goes back. And so basically, I think it even tells you, right, that even if we're like 1 or 2 years from the year of Jubilee, I shouldn't withhold my obligation or my right to lend you money if it's only going to be for a couple of years there.
Right. And back in biblical days, it was every 7 years. You had to release somebody of the obligation to pay you, because otherwise they'd be a slave to you forever.
Forever. But there's a difference. There's a year of Jubilee, which is every 50 years, and then there is are those years. And even the land was supposed to be given a rest in between for plowing.
Yeah. So my point is, this goes all the way back to the beginning of time.
Well, let me ask you this, Dave. So in the chapter 7, where we're getting rid of everything else, the lien stripping isn't available to me. A lot of people think in a chapter 7. And again, everything, so that folks know, it's fact specific. Each case is unique and each case is different, so you need to know exactly what it is. So we can't just tell you this is what it is and this is generally the way that it's going to happen. We could just give you an idea. So a lot of people think that, hey, listen, you know what, this is what I'm going to do. I owe money on my house, I've got a second mortgage, I've got a car, I'm going to file bankruptcy on everything and keep everything, Dave.
Well, you can keep everything, but you're going to have to continue to pay for that house and or car, because those are secured items. So if you don't make the payment, the mortgage company or the auto finance company has the ability to repossess or foreclose on that secured interest.
What's a secured item?
A secured item would be a house with a mortgage on it, a vehicle with a lien against it, a TV, furniture, jewelry, electronic purchase that has not been paid for yet. So there's still a purchase money security interest.
So if I bought something with my credit card, then that is, so if I bought a laptop with my credit card, that is a secured debt?
No, it's technically unsecured if you put it on a credit card. It's secured if you bought it specifically from the store that issued you the financing.
If I got financing from the store. Okay,
right.
Like renting furniture from whatever, one of those places.
Well, renting would be different. That'd be a rental. There'd be
no, but you know, rent with to own. So basically, if I bought furniture from Dania and they gave me the furniture and they're the one that are financing my loan, then that's secured.
That's right. And typically, they don't want the furniture back after it's been in your house for a year or two. They want to work something out where you pay them the fair market value.
Especially if I had 5 kids.
That's right. Especially if you've been sitting on it for 2 years, watching TV, eating on it and all that stuff. It's just wear and tear. They can't put it back in the store and really sell it for anything. So, but that's what a secured creditor is. So think of a mortgage, think of an auto financing company where if you don't make a payment, there's something that could be given back or taken from you.
But you can, though, in a Chapter 7, again, so you could still keep it. So I could still, provided I don't have too much equity in my home and I don't owe anything on it, I'm caught up to date, that is to say, I could still keep my home.
Yes, you would just need to stay up to date and keep making that first and or second mortgage payment, keep paying the association if it's a condo, the real estate taxes. Those items have to be paid, otherwise you can lose it in a non-bankruptcy method.
Is that, when I do it in the bankruptcy method and I keep it, is that, because I have a choice, right? I could give it back or I could keep it.
That's right. If you decide to file bankruptcy and surrender the house, which a lot of people are doing now because their houses have fallen in value to the point where they don't have any equity in it. They owe more than what the house is worth. A
lot more.
Which is also known as being upside down or underwater. There's a lot of different words for it.
Sure.
Yeah, they can file a Chapter 7 and walk away from the house. And they don't necessarily have to leave the house right away. The mortgage company still has to take them through the complete foreclosure process to get the house out of the homeowner's name and into the bank's name.
And then generally after, you typically have a redemption period after the sale, do you not?
After the sale and a foreclosure?
Right.
Yeah, there's a couple different redemption periods. Let's just suffice to say if you're trying to save your home or you're trying to stay in your home and wait out the foreclosure period, you're probably looking at least 11 to 12 months in the state of Illinois right now.
So that's 11 or 12 months that I could be saving money to be able to procure a rental place for my family.
That's right. And the mortgage company might even make you an offer, cash for keys. They might offer you $3,500 to leave the property in good condition and leave sooner, as opposed to making them go through the complete foreclosure process. So sometimes clients of mine actually get a little walking bonus when they leave their house, in addition to eliminating the debt. So it really is a lifesaver, Chapter 7, in many cases. It gives you a fresh start.
Fresh start.
From one day to the next, Jesse, you can go from being totally in debt to being debt-free.
So
how great is that?
That's awesome, and it's fantastic that we're able to have that available to us here, especially in these times.
Yeah, but it's for honest people. It's not for anything fraudulent. You have to be an honest debtor. You can't have incurred this debt by fraud.
Are you saying
you can't
that
run up the credit cards? You can't do anything illegal. It's for honest debtors who just found themselves in the traps.
Are you saying that there are dishonest debtors availing themselves of the bankruptcy process?
Well, there are some. I don't see as many as the government would lead you to believe there are, which is why they claim the bankruptcy laws needed to be reformed October 17 of 2005.
Has it been that long?
It's been that long. But there's enough people looking between the U.S. trustee, the panel trustee, and creditors, of course, and creditor attorneys who will kind of look to see if there's been some kind of fraud or run-up, or if someone's not putting all of their disposable income on paper.
Or so, hey, if I, I get this laptop and I get a couple of flat screen, ultra skinny televisions, and then I file for bankruptcy after I've maxed my card out, they're going to be looking at that.
Yeah, they're going to know that, and they're going to file a objection or an adversarial complaint trying to hold that debt to be non-dischargeable.
So even though, despite the bankruptcy, if they're successful, I'd have to pay it back.
That's right. Or you'd have to give the item back, or both. Or worse, if you commit fraud, you can be denied a bankruptcy discharge, which means you'd never be able to eliminate those debts for life and possibly be put in prison.
Well, that's what I was thinking. That's probably the worst of that, being put in prison for that, for sure.
Yeah,
for sure.
The toughest remedy is that.
Now, what happens, you talk about the Chapter 7. I could keep it, I could stay in the house or not, and keep it or give it back. And so if I decide that I'm going to keep it, now I filed the bankruptcy, and now what's the limit on a Chapter 7? If I file a Chapter 7 now, when can I file another Chapter 7? Not that I'm wanting to do that and hopefully not in that position again, but how long before I could file that again?
You can file a Chapter 7 every 8 years, but my hope is
8 years
this.
in a day, right?
One day into the 8th year, yes. But my hope, Jesse, is once someone gets out of debt through my services or through my office, that they're not going to fall back into debt. Because I kind of help them. I give them tips and tricks and start getting them to budget and set goals and try and spend money wisely, and I give them material to that effect. So hopefully it's a one-time deal and they don't need to file again after 8 years. But that's when they would be able to avail themselves of the relief.
Provided they're eligible in every other respect.
Yeah, they have to be under a certain income level. It depends on the family size. It depends on the total debt. And it depends on if they have assets, whether or not those assets can be protected. Because there's only a certain dollar limit that you can keep in property and still get out of debt.
Well, other than the $2,500 car exemption, what else? What's the wild card on for the?
Well, there's a $4,000 wild card exemption that you can put over any kind of personal property, not real estate, so not a house, but you can put $4,000 miscellaneous over any kind of property, including a vehicle.
So with that, so realistically, I have $6,500 to a vehicle if I needed it, but then that would not allow me to take other exemptions for personal property like clothing and personal jewelry and stuff like that.
Right.
Now, I'm getting back to the house here on the Chapter 7. So if I decide that I'm going to keep my house, I'm going to reaffirm, does that mean now, even though I've done my bankruptcy now, I'm stuck with the house? If I change my mind later, I'm out of luck. Is that right?
No, you're not going to reaffirm on the house.
I'm not.
You're going to make voluntary payments on the house because the bankruptcy code allows for real estate for you to continue to make monthly payments without reaffirming. With a vehicle, though, however, or any other type of secured debt, you must make a decision. Surrender the item, redeem it, which means pay a one-time lump sum payment for the fair market value, which nobody can do because they don't have any money, they just filed bankruptcy. Or 3.
That's only if you've got more equity in the vehicle than you have available for your case.
And lastly, you'd want to reaffirm on a vehicle, which means you agree to sign on the dotted line to be subject to that debt and those payments once again.
Notwithstanding the bankruptcy.
Notwithstanding the bankruptcy. It's like putting yourself back on the hook. Now, here's the problem, or potential problem. If 6 months down the road or so, you find that you can't make that car payment or the car breaks down on the side of the road,
you're out of luck.
You're on the hook for that debt, and the creditor can sue you again and collect.
Now, what's the difference between that and the house?
The house is treated differently. The house, you don't have to reaffirm under the bankruptcy code. You can make voluntary payments, which is what I recommend. I never recommend anybody reaffirm the debt on the house because they're putting themselves back on the hook.
So what happens on the house then? Let's say we did our bankruptcy here, and I'm paying, and now all of a sudden something happens and I can't pay anymore.
You can simply surrender the house back or make the mortgage company go through the full foreclosure process.
But I'm off the hook for that debt.
You're off the hook for the debt. They're not going to be able to sue you for any monetary amount.
How about the association fees?
Association is a little different. You're on the hook for the association for as long as you are the owner of the property. So in this example where someone's going to give up the property and they eliminate the debt to the mortgage company in a Chapter 7, they're technically on the hook for the association fee until the property is no longer theirs, which means until it goes to a foreclosure
and
sale.
it goes to the sale.
Or if the mortgage company is willing to accept a deed in lieu of foreclosure.
So that's not discharged to the bankruptcy?
It's not discharged from the post-filing of the bankruptcy until the time that the debtor is no longer the owner. It's a little bit of a tricky area there.
So basically what you're saying is everything up until that point is discharged. However, anything after the filing, the association fees that accrue from that point on are still owed.
Yes, so I would advise a client who wants to keep the house or who doesn't want to keep the house but wants to live there until it's no longer theirs to continue to make the association payment only.
At least.
Yes, at least. And insurance and utilities.
Okay. And so just so that the folks have a basic understanding of that, now switching here to a 13, which is a whole lot different. It's not a fresh start. Well, it is in some instances, really, but it's really a debt consolidation plan that everybody has to follow. It's not like one of these places where they're pitching on television where you call up and you say, hey, we can help you and we'll lower your debts and get everything, because the debtors don't have to, or creditors don't have to go along with that program, do they, Dave?
That's right. Debt consolidation that you see on TV doesn't have the strength that Chapter 13 has, because creditors don't have to agree to be part of that repayment plan. Whereas in Chapter 13, they either have to be part of the payment plan or the debt is eliminated. So it has a lot of strength. So here's how it works in this case. You'd pay back either all or a portion of your debt. So in many cases, somebody who does a Chapter 13 and might have $100,000 worth of credit card debt can often pay back $10,000 and eliminate the other $90,000 worth of debt.
Or depending upon their circumstances, they and the term of the plan and the plan payments, they may even at the end of everything, at the end of the 60-month period, which is the longer end of that, is to actually pay everything in full.
They could. You can. That's called a 100% payment plan. That's not a problem. If somebody owes $10,000 or $20,000, we stretch it out over 60 months.
What would be the benefit for that? If I'm going to have to pay everything back 100%, why would I do that, Dave?
Well, it stops the interest on the credit cards. It stops the collection
efforts. You mean
efforts.
the 9%?
The 29.9%.
Wow.
It stops that. It stops collection efforts. They can't be sued. They can't be garnished. It stops the harassing phone calls, the harassing letters. It basically gives them an opportunity to repay the debt over a 60-month period relatively stress-free. I mean, they still have to put whatever they have available towards the Chapter 13 repayment plan, but it gives them some breathing room typically where they can live their life again and make that comfortable payment to repay the debt.
And like you were mentioning a little bit earlier in the program here about the stripping of the lien for the second mortgage. Wow, I mean, because if I had a $100,000 second mortgage, so basically at the end of this thing, I could come out with just owing the initial mortgage.
Yeah, this is something new, Jesse, over the last couple of years with home values dropping and people who had taken out a second mortgage to maybe pay off credit card debt, which, by the way, they've probably maxed out the credit cards again. It's never a good idea to do that. But those companies that solicited the second mortgages heavily are the ones that are being subject to this stripping. So it's kind of like...
Elaborate just a little bit more of that. What do you mean that they have... solicited those?
Let's go back 5 or 10 years. You'd see a lot of ads on TV saying, take out a home equity loan, pay off debt, buy a car, do this kind of stuff with the equity put that equity in your house to use. Well, they did. They went and got a second mortgage or a line of credit, and now as the value of the homes have dropped, that second mortgage or line of credit is completely unsecured, meaning the first mortgage, if the house were to be sold, there'd be enough money to pay the first mortgage, if that, and nothing else. So the second mortgage has lost their security interest because the value has dropped. We can treat those second mortgages as unsecured debt in a Chapter 13. So anybody at home who's sitting there with a house that's underwater and they have a second mortgage that's completely unsecured can avail themselves of Chapter 13 and get a nice break on the debt.
So it really puts the American dream back into perspective for those folks because they figure, okay, well, if I have to pay this and I've got to pay that one, there's no way that that's really going to happen.
Yeah, well, it basically takes the debtor and puts them in a good position because the mortgage company probably wouldn't work out any modification. They weren't able to work anything with a second mortgage, but by bankruptcy under Chapter 13, they change the nature of that second mortgage and turn it into a unsecured medical bill, an unsecured credit card, a utility bill. It changes the character. Now, one caveat here, they must complete the Chapter 13. the stripping doesn't happen instantly. The stripping really happens in full effect once the case goes to a discharge.
You have to be successful in paying all of your planned payments and everything else.
But that's a good incentive if you know your $80,000 second mortgage is going to be paid $8,000 and then it'll be gone. That's got to be some incentive there to keep that payment going.
Right.
And
I was going to say, and everybody's situation is different. It's based upon their income. It's based upon their economic position. It's based upon what they have available after their allowable expenses.
That's right.
So, I mean, somebody, for example, who is making $500,000 or $300,000 a year is someone who's probably going to do that 100% plan that we're paying back.
That's right. The trustee is the person who looks over the Chapter 13 petition and actually administers the payments on behalf of the creditors. That trustee is going to make sure that you are putting all of your disposable income into the plan. So if you have a lot of disposable income, you're going to be paying back a greater portion of your debt. If you have significant income, you're going to be required to pay back in full and oftentimes plus interest.
Wow, so if I were a video producer for, let's say, a cable show, that's probably something I'd be on the hook for.
You would definitely be on the hook for it and have to pay back either a percentage or all of your debt. But that's the best thing about Chapter 13 is you're restricting the creditors, you're often paying back less than what's in full, and you're saving a home usually. You're either repaying mortgage arrears or, in this case, stripping that second mortgage and turning it into an unsecured debt.
Go back a moment. You've mentioned about a loan modification where I know there's a lot of people, because I've talked to a lot of people who have inquired into that. And in fact, there are even attorneys who have started doing loan modification, and other companies that will assist people to do the loan modification in order to, and basically what that really encumbers is, really, let's be realistic. They're not getting that much of a break. What they're doing is they're just putting everything on the back end and extending the mortgage out. I mean, realistically, is that right?
In many cases, that's true. Sometimes they're lowering the interest rate for a limited time.
So basically, we're back to the variable rate again, which is what got you into the trouble in the first place, right, Dave?
It is, but what the benefit here, if any, is that the homeowner is getting extended time in the home. So even if they're going through this trial period, even if the arrears are being put towards the back, they're getting some time. They're getting the ability to get an opportunity to change their financial situation to the point where they can either save that house or have the time to find alternate housing.
Well, you had mentioned, we talked about a little bit earlier, about being able to save your house in a Chapter 7 if you didn't have too much equity and if you didn't have any arrears. You mean that is, you didn't owe anything kind of back, mortgage payments to the mortgage company. So if we entered into this loan modification deal, and then I was able to do a bankruptcy. So let's say we have a deal. I owe $30,000, $40,000, and then we make the loan modification agreement. And so now I've got an agreement. We're good to go. Now I can do the bankruptcy and not have to worry about losing the property, where before I'd have a real issue because I owed that difference, correct?
As long as you had the loan modification in place before you filed the bankruptcy, that agreement would stand. What we're seeing sometimes here is that once someone initiates the bankruptcy, the mortgage company doesn't want to work out a loan modification until the bankruptcy is either completed or they're requiring the debtor to reaffirm on the mortgage.
Which is what you said, that it's not a good idea to do.
I will not allow it. I consider it malpractice. So the way I look at it, the mortgage company has the ability to work out a loan modification whether or not the debtor reaffirms on the mortgage. So they're using that as an excuse, I believe, to try and get the debtor back on the hook for the mortgage, and I won't allow it.
Because it doesn't offer the same protection that obviously they would have not having to worry about it in the future.
Right. There's no benefit to it. The person can keep the house provided they make the payments, or if they can't make the payments down the road, they have the ability to walk away. I don't want to strip them, no pun intended, of that ability, as we're talking about lien stripping. But Chapter 13 is typically, Jesse, to save a home. And I'm going to do whatever I can to make sure that they can keep that home. And if I can turn that second mortgage into an unsecured debt, we're going to do it.
You seem like the magic man there, Dave, right? Helping these folks out with real problems that everybody has, especially in this economy.
Well, it's kind of like a newfound ability. I mean, I always had the ability to take the part that they fell behind on the mortgage, put it in a big pot, throw in all their other debt, throw in their car, and give them one place to pay, and $1 amount, but they had to pay it all back if it was secured. Nowadays, with the home values being what they are, I can really look across the table with someone and say, you know what, I have the ability to probably take that second mortgage. Some people have 3 mortgages, Jesse, and turn those mortgages into unsecured debt, which is just a huge amount of savings depending on how high that second mortgage was. The example I'm giving, $80,000.
Right.
I've seen them a lot higher than that.
Does that happen too with the third mortgage? If they have a third mortgage, the same principle applies, correct?
Absolutely, at a strip too. Third mortgage turns into an unsecured debt easily because they're in third positions. They're definitely unsecured.
So they're definitely, and then it just goes up from there. Wow, that's really remarkable.
One other thing, Jesse, that I'm seeing a lot of lately that I wanted to mention, and I guess this is a sign of the times. Mm-hmm. I'm seeing people who are strategically now walking away from their home. 3 to 5 years ago, it was people who couldn't make the mortgage payment. It was adjusting on them. They were losing their job. They couldn't pay for it. Now I'm seeing people who have the means and the ability to pay for their mortgages, but are strategically saying, you know what, I don't want to pay on a mortgage when my property has dropped so much in value. It doesn't make fiscal business sense for me to do that anymore. I'm going to let this house go, especially if it's in Cook County. The mortgage company can only take the property back. They can't sue the person for any money.
Explain a little bit about that.
Yeah, there's in foreclosure, there's something called a deficiency judgment. In some counties in Illinois, if the mortgage company goes through foreclosure and gets the house back and they get less than what's owed, they can get a monetary judgment against the homeowner. In Cook County...
Just like a car.
Right.
A repossessed car.
Right. In Cook County, if it's your primary residence, the judges at this point are not entering deficiency judgments. So the mortgage company is just getting the property back, and the homeowner is being able to walk away.
From just giving the property back. And that's something they would have to come in after the sale.
That's right. Well, they do it contemporaneous with the foreclosure proceeding, but yes, it's after the sale.
Because you wouldn't know what you were getting. Now let me ask you this. What's the time period? What's the very last available moment that I could save my house in a Chapter 13 bankruptcy? I mean, we've got the sheriff's sale, then we've got a 30-day redemption period, which would allow me to pay what I owe back to get my property back, right?
Through state law, but not through bankruptcy law. Under bankruptcy law, you must file that 13 just prior to the sheriff's sale being concluded. So the minute that gavel goes down at auction,
you're done.
You're done as far as Chapter 13. You do still have some state court rights.
Right, which is if I was able to get a short sale or be able to do whatever I can in 30 days. But basically, right before that gavel goes down, okay, it's 9:05, and you just filed the bankruptcy. 9:07, sold.
You're protected because you filed that bankruptcy before the gavel went down, before the property was auctioned off. You saved it by filing a bankruptcy. The filing created an automatic stay, which is a big stop sign that goes
even if you didn't know about it? Even if, how could I possibly know that you just filed it and boom, we just concluded a deal here?
Yeah, bankruptcy will still save you. Now that person who bought it at auction is going to think that they were the winning bidder, which they were, but in reality they're not going to be able to get...
It's going to be set aside.
It's going to be set aside. They're not going to be able to get confirmation of that sale because the bankruptcy protection kicked in. This is federal law, extremely powerful. Timing is everything. If you beat it by a minute, you've saved your house, or at least given you the opportunity to save your house through Chapter 13. So I strongly recommend, Jesse, if you're someone in foreclosure, don't wait till the last minute.
And that happens a lot, Dave. I've seen a lot of people who come in, and it's the last minute, not just for that, but for a lot of other things as well.
That's true. People often don't come in until they're actually being sued or garnished, or they receive a sheriff's sale notice. So that's really what it's all about. Any questions, Jesse? People can reach us at Legal Action TV or questions at Legal Action TV. Thanks for joining us. We've been talking about bankruptcy, Chapter 13, with an emphasis on lien stripping that second mortgage. We'll see you next time on Legal Action. Take care.